Getting ready for your real estate exam? Birdsey has you covered with a series of videos covering everything you need for exam day. This is National Part 2, focusing on real estate practice and contracts. Be sure to pay attention to what's happening in the bottom corner. It'll be key to your prep. Now, let's get started.
Now, let's spend some time reviewing real estate practice. We'll begin with agency relationships and duties. What is the primary fiduciary duty owed by an agent to their principal? Is it A, obedience, B, C, disclosure, or D, confidentiality? The answer is B, loyalty. Loyalty is a fundamental fiduciary duty where an agent prioritizes the principal's interests above all, including personal gain. Which of the following is a true statement regarding dual agency? Is it A, both parties must consent in writing? B, it eliminates the need for confidentiality? C, the agent can accept higher commission without disclosure? Or D, one party needs to consent verbally? The answer is A, both parties must consent in writing. Dual agency requires informed written consent from both parties, ensuring transparency and protecting interests.
Have you noticed the code in the bottom corner? Next time you're stumped, take that code to birdsey.ai for immediate help and a free study session with Birdsey, your personal AI study partner. Plus, you'll get access to hundreds of additional questions, helping you move closer to passing your exam with confidence. The next time you're feeling unsure or stuck, give it a try.
In a buyer's agency agreement, which duty is not owed to the seller? Is it A, honesty, B, fiduciary duty, C, disclosure of facts known to buyer's interest, or D, care? The answer is B, fiduciary duty. In a buyer's agency agreement, fiduciary duties are strictly for the buyer, guarding their interests exclusively. A real estate agent fails to disclose a known defect in the property. What fiduciary duty has been breached? Is it A, loyalty, B, confidentiality, C, disclosure, or D, care? The answer is C, disclosure. Disclosure requires an agent to inform their clients of all material facts about a property or transaction, ensuring clients make informed decisions. In an agency relationship, when is the duty of accounting violated? Is it A, an agent fails to communicate offers? B, the agent mixes personal funds with client funds? C, the agent provides advice on market analysis? Or D, the agent does not negotiate the best price? The answer is B, the agent mixes personal funds with client funds. The duty of accounting requires agents to maintain clear, separate accounts for client funds, avoiding any personal commingling. What type of agency relationship allows an agent to act on behalf of a principal, yet the principal can continue to negotiate with multiple agents? Is it A, exclusive agency, B, dual agency, C, single agency, or D? The answer is D, opency. An open agency does not restrict the principal from engaging multiple agents, unlike an exclusive agency. The agent who secures the transaction earns the commission. In a fiduciary relationship, which duty obligates the agent to act in the best interest of the principal? Is it A, B, disclosure, C, reasonable care, or D, obedience? The answer is A, loyalty. The duty of loyalty ensures that agents prioritize the principal's interest above all else, avoiding conflicts of interest and self-dealing. Which duty requires an agent to inform the principal of all known facts that could affect the transaction? Is it A, confidentiality, B, disclosure, C, accounting, or D, loyal? The answer is B, disclosure. The duty of disclosure requires agents to pass on all relevant information that might influence the principal's decision in the transaction. What duty is breached when an agent shares sensitive client information with a competing party? Is it A, obedience, B, confidentiality, C, accountability, or D, disclosure? The answer is B, confidentiality. The duty of confidentiality prohibits agents from sharing a client's personal and critical information without consent, even beyond the transaction's close. Which of the following duties is primarily concerned with maintaining accurate records of financial transactions between agent and principal? Is it A, disclosure, B, confidentiality, C, accounting, or D? The answer is C, accounting. The duty of accounting mandates agents to manage, track, and report on financial transactions with clients, ensuring transparency and accuracy. Which of the following actions demonstrates a breach of the duty of loyalty in a real estate agency relationship? Is it A, disclosing a client's lowest acceptable price to a potential buyer, B, providing accurate information about the property to all potential buyers, C, strictly following the client's instructions, even if it leads to a longer sale process, or D, informing the client of all offers received, regardless of their amount? The answer is A, disclosing a client's lowest acceptable price to a potential buyer. The duty of loyalty requires agents to prioritize their clients' interests. Disclosing sensitive information like the lowest price a client will accept could harm the client's negotiating position. Which of the following is the primary obligation of an agent under a fiduciary relationship? Is it A, to maximize the property's sales price, B, to reduce transaction time as much as possible, C, to ensure both parties have equal information, or D, to act in the best interests of the client? The answer is D, to act in the best interests of the client. In a fiduciary relationship, the agent's primary obligation is loyalty to the client, which includes acting in the client's best interests and maintaining confidentiality. What is the main purpose of dual agency disclosure? Is it A, to comply with federal real estate laws, B, to inform the client about potential conflicts of interest, C, to guarantee the highest sale price for the property, or D, to minimize agent liability in transactions? The answer is B, to inform the client about potential conflicts of interest. Dual agency disclosure is critical in informing both parties about the agent representing conflicting interests, allowing them to make informed decisions about consent.
If you're finding this helpful, please take a minute to like this video and subscribe to our channel for more practice exams, useful tips, and complimentary study sessions with Birdsey.
Fair housing laws. Which of the following is a prohibited practice under the Fair Housing Act? Is it A, refusing to rent based on credit history, B, offering different terms based on race, C, charging higher rent based on credit risk, or D, refusing to rent to smokers? The answer is B, offering different terms based on race. The Fair Housing Act prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability. What is steering in the context of real estate, and why is it illegal? Is it A, directing buyers to neighborhoods based on income, B, directing buyers to neighborhoods based on race, C, refusing services to clients based on credit history, or D, providing market analysis for specific areas? The answer is B, directing buyers to neighborhoods based on race. Steering is the practice of guiding prospective homeowners towards or away from certain neighborhoods based on race, violating the Fair Housing Act. Which party is not typically exempt from Fair Housing Act provisions? Is it A, owner-occupied buildings with no more than 4 units, B. Single-family homes sold or rented without a broker. C. A commercial property owner renting retail space. Or D. A corporate owner of a large apartment complex. The answer is D. A corporate owner of a large apartment complex. The Fair Housing Act generally applies to all residential housing, with limited exceptions, such as certain small, owner-occupied properties and private sales by owners. Which type of property modification must landlords allow under the Fair Housing Act? Is it A. Installation of a satellite dish? B. Structural changes for aesthetic reasons? C. Modifications to accommodate a disability? Or D. Renovations to improve energy efficiency? The answer is C. Modifications to accommodate a disability. Landlords must allow reasonable modifications for disabled tenants to live comfortably, though the tenant may be responsible for the costs. How are familial status discriminations defined under the Fair Housing Act? Is it A. Refusing applications from single persons? B. Allowing non-disabled residents only? C. Denying housing to families with children under 18? Or D. Renting only to married couples? The answer is C. Denying housing to families with children under 18. The Fair Housing Act protects against discrimination based on familial status, ensuring families with children under 18 are not unjustly denied housing. What act prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability? Is it A. Equal Credit Opportunity Act? B. Fair Housing Act? C. Civil Rights Act of 1964? Or D. Americans with Disabilities Act? The answer is B. Fair Housing Act. The Fair Housing Act, enacted in 1968, prohibits discrimination in housing based on race, color, national origin, sex, familial status, and disability. It is monitored by the U.S. Department of Housing and Urban Development. Which of the following is considered a prohibited practice under the Fair Housing Act? Is it A. Refusing to rent to a tenant based on their disabilities? B. Offering incentives for quick rental applications? C. Charging differing security deposits based on pet ownership? Or D. Advertising rental properties on social media? The answer is A. Refusing to rent to a tenant based on their disabilities. The Fair Housing Act prohibits practices such as refusing to rent to tenants because of disabilities. Landlords must also accommodate tenants with disabilities by making reasonable modifications. Under the Fair Housing Act, which action is not considered discriminatory? Is it A. Providing different services to tenants based on religion? B. Charging more rent to families with children? C. Refusing to provide reasonable accommodation for disabled persons? Or D. Offering a property promotion to all applicants equally? The answer is D. Offering a property promotion to all applicants equally. Offering a promotion equally to all applicants is not discriminatory. The Fair Housing Act requires equal treatment and prohibits discrimination based on protected characteristics. What should a landlord do when facing a request for a reasonable accommodation from a disabled tenant? Is it A. Deny the request immediately? B. Consider the request and determine if it is reasonable? C. Allow it only if other tenants agree? Or D. Charge a fee for accommodating the request? The answer is B. Consider the request and determine if it is reasonable. The Fair Housing Act requires landlords to provide reasonable accommodations for tenants with disabilities unless it causes undue hardship or fundamentally alters the nature of the housing service. Ethics and professional conduct. Which of the following is considered a breach of a real estate agent's duty of loyalty to their client? Is it A. Disclosing confidential information to gain a personal advantage? B. Setting a fair market price for a client's property? C. Communicating regularly with clients during a transaction. Or D. Failing to suggest a higher listing price than the client desires. The answer is A. Disclosing confidential information to gain a personal advantage. A real estate agent owes a duty of loyalty to their client, prioritizing the client's interest even above their own. Disclosing confidential information for personal gain is a clear breach. When a real estate agent represents both the buyer and seller in a transaction, it is known as, is it A. Exclusive agency, B. Dual agency, C. Open listing, or D. Single agent? The answer is B. Dual agency. Dual agency requires full disclosure and consent from both the buyer and seller, as it can lead to conflicts of interest. Which of the following is true regarding a real estate professional's duty to disclose defects in a property? Is it A. They must disclose all known material defects, B. They only need to disclose defects if asked by the buyer, C. They do not need to disclose potential defects, or D. They can rely on the seller's disclosure only? The answer is A. They must disclose all known material defects. Agents have a duty to disclose any material defects they know of that could influence the decision-making of a buyer. What is the primary purpose of the Real Estate Settlement Procedures Act? Is it A. To ensure fair housing practices, B. To regulate commission structures, C. To protect consumers from unnecessarily high settlement charges, or D. To mandate continuing education for real estate professionals? The answer is C. To protect consumers from unnecessarily high settlement charges. RESPA requires transparency in real estate settlement costs and prohibits certain abusive practices to protect consumers. If a real estate professional encounters a situation that is ethically unclear, what is their best course of action? Is it A. Proceed based on personal judgment, B. Consult the Code of Ethics and seek advice, follow the least resistant path, C. Ignore the situation to avoid conflict, or D. Consult the Code of Ethics and seek advice? The answer is D. Consult the Code of Ethics and seek advice. Consulting the Code of Ethics and seeking guidance from more experienced professionals helps maintain ethical conduct and public trust. Which of the following actions best demonstrates a real estate agent adhering to ethical guidelines? Is it A. Disclosing only favorable information about a property, B. Keeping client information confidential unless legally required to disclose, C. Encouraging a client to make an offer above their budget, or D. Showing a preference for cash buyers over others? The answer is B. Keeping client information confidential unless legally required to disclose. Real estate agents must maintain confidentiality and handle client information with care unless disclosure is legally mandated. This is a fundamental aspect of ethical conduct. What is considered an ethical breach in real estate practice? Is it A. Communicating with potential clients through professional channels, B. Providing accurate market information to clients, C. Misrepresenting property details to potential buyers, or D. Offering referrals to approved service providers? The answer is C. Misrepresenting property details to potential buyers. Misrepresenting property details to buyers violates ethical standards, as agents must provide truthful and accurate information to all parties involved. How should a real estate professional handle a conflict of interest situation? Is it A. By ignoring the conflict and proceeding as usual, B. By disclosing the conflict to all parties involved, C. By acting solely in their own best interest, or D. By seeking guidance from the State Real Estate Commission? The answer is B. By disclosing the conflict to all parties involved. Proper ethical conduct requires real estate professionals to disclose any potential conflicts of interest to all affected parties, ensuring transparency and fairness.
Don't forget to comment below with your tips, challenges, and thoughts on exam preparation. Your experiences can make a big difference for others.
Listing agreements. What is the primary purpose of a listing agreement in real estate? Is it A, to authorize the agent to represent the seller in the sale of the property? B, to determine the buyer's financial qualifications? C, to include the property incognito in the MLS system? Or D, to set the selling price of the property without market adjustments? The answer is A, to authorize the agent to represent the seller in the sale of the property. A listing agreement is a legally binding contract that gives a real estate agent the right to act as the seller's representative in the sale of property. Which of the following is not typically included in a listing agreement? Is it A, listing price, B, broker commission rate, C, terms under which the property is available for showing, or D, buyer's financial obligations? The answer is D, buyer's financial obligations. Listing agreements primarily detail the agent's duties, commission, listing price, and terms for showing the property, but do not cover buyer's obligations. What does the exclusive right to sell listing agreement provide to the broker? Is it A, a non-compete agreement with other agents? B, assurance of commission payment if the property is sold by any party? C, ownership rights to the property being sold? Or D, limited marketing opportunities for the property? The answer is B, assurance of commission payment if the property is sold by any party. An exclusive right to sell listing guarantees the broker's commission regardless of who sells the property, incentivizing the broker to market it actively. Under a multiple listing service arrangement, how is the property made available? Is it A, the property is only shown to exclusive clients of the listing broker? B, listed privately with no public access? C, visible to all agents and brokers connected with the MLS? Or D, limited to a certain geographic area or client base? The answer is C, visible to all agents and brokers connected with the MLS. The multiple listing service enables cooperating brokers to access property listings, greatly expanding market exposure and potential buyers. How can a listing agreement typically be terminated? Is it A, only upon mutual agreement between the agent and the seller? B, by death of either the seller or the broker? C, only by breach of terms of the agreement? Or D, through automatic extension clauses for indefinite terms? The answer is B, by death of either the seller or the broker. A listing agreement can terminate on grounds such as the fulfillment of the sale, expiration date, mutually agreed upon termination, or death incapacity of the broker or seller. What is the primary purpose of a listing agreement in real estate? Is it A, to secure a loan for the property? B, to outline terms under which a real estate agent will sell a property? C, to establish zoning laws for a property? Or D, to evaluate home insurance policies? The answer is B, to outline terms under which a real estate agent will sell a property. A listing agreement is a contract between a homeowner and a real estate broker authorizing the broker to sell the property. It usually outlines the terms and conditions of the sale process. Which type of listing agreement allows a property owner to sell their property independently without paying a commission? Is it A, exclusive right to sell? B, net listing? C, open listing? Or D, exclusive agency? The answer is D, exclusive agency. Exclusive agency agreements allow property owners to retain the right to sell the property themselves without owing a commission to the listing agent if they find the buyer independently. Which element is commonly not included in a standard listing agreement? Is it A, property address, B, commission rate, C, zoning restrictions, or D, duration of agreement? The answer is C, zoning restrictions. Listing agreements focus on the terms of selling a property, such as commission and duration. Zoning restrictions are usually addressed through separate documentation concerning property use.
Notice the code in the corner? When you're stumped by a question, enter it at birdsey.ai for immediate help. Enjoy complimentary study sessions and access to hundreds of additional questions to help you pass your exam with confidence.
Buyer representation agreements. What role does a buyer representation agreement play in real estate transactions? Is it A, provides exclusive legal representation for the buyer by the agent, B, ensures the buyer pays the seller's commission, C, allows the buyer to use services of any agent without commitment, or D, prohibits any dual agency agreements? The answer is A, provides exclusive legal representation for the buyer by the agent. A buyer representation agreement formally establishes the relationship between the buyer and real estate agent, ensuring loyalty and obligation towards the buyer's interests. Which of the following is typically included in a buyer representation agreement? Is it A, the address of the property the buyer intends to purchase, B, terms of compensation for the buyer's agent, C, importance of the multiple listing service, or D, an exclusivity clause for the seller's agent? The answer is B, terms of compensation for the buyer's agent. The buyer representation agreement often specifies the agent's compensation terms, which may include commission or flat fees agreed upon by buyer and agent. When does a buyer representation agreement typically become effective? Is it A, upon the buyer's initial contact with the agent, B, once the buyer attends the first property viewing, C, after the agreement is signed by both the buyer and agent, or D, when the agent presents the first property listing? The answer is C, after the agreement is signed by both the buyer and agent. Buyer representation agreements are legally binding once signed by both the buyer and the agent, formalizing the agency relationship. What is the typical duration of a buyer representation agreement? Is it A, indefinite until the buyer finds a property, B, specifically determined between buyer and agent, C, automatically expires after each property showing, or D, typically 3 months as per national requirement? The answer is B, specifically determined between buyer and agent. The length of a buyer representation agreement is agreed upon by the buyer and agent and can range from weeks to months based on mutual consent. How can a buyer representation agreement be terminated before it expires? Is it A, only if the buyer purchases a property, B, automatically when the buyer meets the seller, C, when the agent cannot find properties matching buyer's criteria, or D, through mutual consent between buyer and agent? The answer is D, through mutual consent between buyer and agent. A buyer representation agreement can be terminated before its expiration when both the buyer and agent mutually agree to end the contractual relationship. What is the primary purpose of a buyer representation agreement? Is it A, to outline the terms under which a broker is paid, B, to establish a contractual relationship between the buyer and the real estate agent, C, to secure a purchase contract on a property, or D, to determine the buyer's creditworthiness? The answer is B, to establish a contractual relationship between the buyer and the real estate agent. A buyer representation agreement establishes a formal agency relationship where the agent represents the buyer's interests. It outlines duties, compensation structures, and rights of both parties. Which component is typically not included in a buyer representation agreement? Is it A, duration of the agreement, B, duties of the buyer, C, specific property details, or D, commission structure? The answer is C, specific property details. Buyer representation agreements focus on the relationship and duties between agent and buyer, not the specifics of a property purchase. They detail duration, duties, and compensation. Under a buyer representation agreement, which duty does the agent owe to the buyer? Is it A, confidentiality, B, making all financial decisions for the buyer, C, guaranteeing the condition of a property, or D, settling negotiations without buyer's consent? The answer is A, confidentiality. One of the primary fiduciary duties an agent owes a buyer is confidentiality. This ensures client information is not disclosed improperly, protecting the buyer's interests. Disclosure obligations. What is the primary purpose of disclosure obligations in real estate transactions? Is it A, to protect the seller from legal action, B, to inform buyers of material facts, C, to finalize legal contracts, or D, to increase property value? The answer is B, to inform buyers of material facts. Disclosure obligations exist primarily to ensure buyers have all necessary information about a property's condition before completing a transaction. Which party is generally responsible for providing property disclosures during a real estate sale? Is it A, the buyer, B, the real estate agent, C, the seller, the real estate agent, or D, the lender? The answer is C, the seller, the real estate agent. Sellers must disclose known material defects about the property to prospective buyers to prevent misinformation and liability issues. How should known hazards like lead-based paint be addressed under disclosure obligations? Is it A, ignore them if the buyer does not ask, B, mention them after closing the sale, C, remove the hazards before selling, or D, provide a notice and lead hazard pamphlet according to regulations? The answer is D, provide a notice and lead hazard pamphlet according to regulations. Federal law requires sellers to disclose known lead paint hazards and provide informational booklets to ensure buyer awareness and safety. What should a seller disclose if their property has been damaged by a natural disaster? Is it A, only if repairs were not completed, B, full details about the damage and repairs, C, nothing if the buyer hasn't directly asked, or D, only if they are legally obligated by the local authorities? The answer is B, full details about the damage and repairs. Disclosing prior damage and repairs ensures transparency, helps buyers make informed decisions, and minimizes future legal disputes. What must be included in a seller's disclosure concerning neighborhood nuisances like noise? Is it A, all known nuisances impacting property's livability, B, only if the noise affects property value, C, only if a neighbor has complained again in writing, or D, nothing, as it is not a physical defect? The answer is A, all known nuisances impacting property's livability. Disclosure of neighborhood issues like consistent noise is vital as they can affect buyer decisions and enjoyment of the property. What is the primary purpose of mandatory disclosure obligations in real estate transactions? Is it A, protect sellers from lawsuits, B, ensure buyers are fully informed about potential property defects, C, increase commissions for real estate agents, or D, speed up the closing process? The answer is B, ensure buyers are fully informed about potential property defects. Disclosure obligations safeguard consumer interests by ensuring transparency about significant property defects or legal issues supporting informed decision-making by buyers. Which of the following is a seller not typically required to disclose? Is it A, a minor paint chip in a bedroom, B, known structural defects, C, past termite infestations that were remediated, or D, legal disputes affecting the property? The answer is A, a minor paint chip in a bedroom. Minor aesthetic issues typically do not require disclosure, while significant defects or issues that could affect the property's value or use must be disclosed. Under federal law, what must be disclosed regarding lead-based paint? Is it A, lead paint usage in surrounding neighborhoods, B, current owner's personal opinions on paint quality, C, all renovations that used any form of paint, or D, presence of lead-based paint in properties built before 1978? The answer is D, presence of lead-based paint in properties built before 1978. Under the Residential Lead-Based Paint Hazard Reduction Act, sellers must disclose known lead-based paint hazards in homes built before 1978. Why is a seller advised to provide a property condition disclosure statement? Is it A, to minimize the risk of litigation from the buyer, B, to make the property more attractive to buyers, C, to avoid providing additional warranties to the buyer, or D, to ensure a higher appraisal value? The answer is A, to minimize the risk of litigation from the buyer. Providing a disclosure statement helps to inform buyers of known issues, thus reducing the risk of future lawsuits alleging misrepresentation or concealment. In a seller's disclosure obligation, when should known natural hazard risks be communicated to the buyer? Is it A, before the close of escrow, B, after signing the purchase agreement, C, during the final walkthrough, or D, after the buyer moves in? The answer is A, before the close of escrow. Natural hazard disclosures must be provided before the close of escrow to inform the buyer of potential risks, ensuring transparency and allowing the buyer to reconsider the purchase. Which document must be provided by a seller to disclose known environmental hazards in a property? Is it A, environmental disclosure form, B, title insurance policy, C, seller's property disclosure statement, or D, lease agreement? The answer is C, seller's property disclosure statement. The seller's property disclosure statement is a critical document in real estate transactions containing essential information on a property's condition and known hazards. It helps buyers make informed decisions. What is the primary purpose of providing a buyer with a lead-based paint disclosure? Is it A, to encourage the buyer to negotiate a lower price, B, to inform the buyer of potential health hazards, C, to comply with local environmental regulations, or D, to ensure mortgage approval? The answer is B, to inform the buyer of potential health hazards. Lead-based paint disclosures are mandated by federal law for properties built before 1978 to inform buyers of health risks associated with lead exposure, promoting informed decision-making.
Stuck on a question? Just think of the Birdsey link in the description as your friendly neighborhood superhero, swooping in to save the day with answers. Feel free to explore it now and return to continue. Simply hit pause, and we'll be waiting when you get back.
Escrow and transaction management. What is the primary purpose of an escrow account in a real estate transaction? Is it A, to manage the buyer's mortgage payments, B, to adjust the property's assessed value, C, to secure the property for the next transaction, or D, to hold funds and documents until contractual conditions are met? The answer is D, to hold funds and documents until contractual conditions are met. An escrow account is a neutral third-party account that holds funds and documents during a transaction to ensure that all conditions are met before closing. This protects both parties until the contract is fully executed. Who is typically responsible for managing the escrow process during a real estate transaction? Is it A, the buyer's real estate agent, B, the escrow agent or company, C, the seller's attorney, or D, the local real estate governing body? The answer is B, the escrow agent or company. The escrow agent or company acts as a neutral third party to manage the escrow process, ensuring all contractual obligations are satisfied and facilitating the closing of the transaction. In a real estate transaction, what happens to the earnest money deposit if the buyer fails to meet the contract conditions? Is it A, it is refunded to the buyer, B, it is forfeited and given to the seller, C, it is split between buyer and seller, or D, it remains with the escrow agent for future holding? The answer is B, it is forfeited and given to the seller. Earnest money is typically forfeited to the seller if the buyer does not fulfill contractual conditions and no protective contingencies apply, compensating the seller for potential market losses. Why might a real estate transaction involve a second escrow account? Is it A, to manage the seller's next home purchase, B, to settle outstanding debts on the property, C, for a simultaneous closing like a contingent purchase, or D, to increase the down payment requirements? The answer is C, for a simultaneous closing like a contingent purchase. A second escrow account is often used in back-to-back transactions, such as contingent sales, to ensure that both the selling and purchasing processes are adequately and independently managed. Which action is required to close an escrow account at the end of a transaction? Is it A, both parties sign the escrow agreement release, B, the depositor withdraws funds, C, the state's real estate commission issues a closing certificate, or D, the escrow agent pays off the buyer's previous mortgages? The answer is A, both parties sign the escrow agreement release. Closing an escrow account involves the completion of all conditions and contractual terms, verified through documentation and signed releases, acknowledging satisfaction and release of all escrow funds and documents. What is the primary purpose of an escrow in a real estate transaction? Is it A, to provide a neutral third party to hold funds and documents, B, to determine the market value of the property, C, to negotiate the terms of the sale, or D, to provide legal advice to the buyer and seller? The answer is A, to provide a neutral third party to hold funds and documents. An escrow ensures fair and impartial handling of funds and documents until all terms of the contract are met. This secures the transaction until all parties fulfill their obligations. Which document is typically required to initiate an escrow process? Is it A, a home inspection report, B, a signed purchase agreement, C, the buyer's earnest money deposit, or D, title insurance policy? The answer is B, a signed purchase agreement. The purchase agreement is crucial as it details the terms of the sale, which allows the escrow officer to begin managing the transaction based on those terms. During the escrow process, who is responsible for paying the escrow service fees? Is it A, the buyer, B, the seller, C, both buyer and seller share the costs, or D, the real estate agent? The answer is C, both buyer and seller share the costs. Escrow fees are generally shared between buyer and seller, but the exact arrangement can vary based on negotiations and terms listed in the purchase contract. What occurs when an escrow is closed? Is it A, the funds and documents are returned to the parties, B, a final inspection is conducted by local authorities, C, the contract is nullified and all parties are released from obligations, or D, the title is transferred to the buyer and funds are distributed to the seller? The answer is D. The title is transferred to the buyer and funds are distributed to the seller. Closing an escrow means all conditions of the sale are satisfied, allowing funds to be distributed and the property title to be transferred officially to the buyer. Antitrust. What is the primary purpose of antitrust laws in real estate? Is it A, to reduce the number of real estate agents? B, to promote competition among real estate agents? C, to stabilize housing prices? Or D, to increase taxation on property sales? The answer is B, to promote competition among real estate agents. Antitrust laws are designed to prevent anti-competitive practices in the marketplace, ensuring fair competition and preventing entities from engaging in monopolies or conspiracies that restrain trade. Which of the following is considered a violation of antitrust laws in real estate? Is it A, setting a common commission rate among competing firms? B, disclosing property conditions to buyers? C, offering sales promotions independently? Or D, advertising properties online? The answer is A, setting a common commission rate among competing firms. Under antitrust laws, real estate agents or firms cannot conspire to set fixed commission rates, as it eliminates competition and harms consumer choice. What is market allocation in the context of antitrust laws? Is it A, dividing potential customers based on their credit scores? B, pooling funds for joint advertising campaigns? C, sharing client information for better service? Or D, allocating territories among competing firms? The answer is D, allocating territories among competing firms. Market allocation agreements among competitors involve dividing geographic areas to avoid competing with one another, which is illegal under antitrust laws as it limits consumer options. Which act makes it illegal for real estate professionals to create cartels? Is it A, Federal Housing Act? B, Sherman Act? C, True Competition Act? Or D, Consumer Protection Act? The answer is B, Sherman Act. The Sherman Act makes it illegal for competing entities to form cartels or make agreements that restrain interstate trade or competition in real estate or other markets. Horizontal price fixing among real estate agents is illegal because is it A, increases property taxes? B, ensures fair competition? C, restricts competitive pricing options? Or D, promotes better service quality? The answer is C, restricts competitive pricing options. Horizontal price fixing is when competitors set prices at a certain level, eliminating competition and violating antitrust laws by depriving consumers of competitive pricing options. Which of the following actions would likely be considered a violation of antitrust laws in real estate? Is it A, setting commission rates independently? B, discussing commission splits with a coworker in the same brokerage? C, agreeing with another brokerage to fix commission rates? Or D, advertising below market listings? The answer is C, agreeing with another brokerage to fix commission rates. Antitrust laws prohibit agreements between brokerages to fix prices, such as commission rates. This practice reduces competition and harms consumers. Let's move on to real estate contracts. We'll start by looking at the required elements of a contract. What is one of the key elements required for a real estate contract to be enforceable? Is it A, offer? B, C, misrepresentation? Or D, anticipation? The answer is A, offer. For a real estate contract to be enforceable, there must be an offer, acceptance, consideration, and legal capacity. The absence of any of these elements can render the contract invalid. In a contract, what does consideration refer to? Is it A, mutual concern? B, negotiation period? C. Exchange of value, or D. Acknowledgement? The answer is C. Exchange of value. Consideration refers to the value that is exchanged between parties in a contract. This can be payment, services, or anything else of legal value exchanged for a promise. Which of the following must be present for a contract to be legally binding? Is it A. An invitation to negotiate, B. A written testament, C. Acceptance, or D. Third-party witness? The answer is C. Acceptance. Acceptance is required for establishing mutual assent, a necessary element for a legally binding contract. Without acceptance, there is no agreement between the parties. Which is necessary to challenge a contract on the grounds of capacity? Is it A. Lack of legal age, B. Unfavorable terms, C. Economic duress, or D. Non-binding resolution? The answer is A. Lack of legal age. Capacity refers to a party's legal ability to enter into a contract. This includes being of legal age and having the mental ability to understand the contract's terms and implications. What does mutual assent in a real estate contract imply? Is it A. Silent agreement, B. Collective discussion, C. Meeting of the minds, or D. Unilateral decision? The answer is C. Meeting of the minds. Mutual assent involves a meeting of the minds where both parties understand and agree to the contract's terms, forming the basis for a binding contract. Which of the following is not a required element of a valid real estate contract? Is it A. Consideration, B. Mental capacity, C. Written format, or D. Family relationship? The answer is D. Family relationship. A valid contract must include offer, acceptance, consideration, legal purpose, and mental capacity. Family relationship is irrelevant. What role does consideration play in forming a real estate contract? Is it A. It ensures the contract is dated, B. It confirms each party's agreement to the terms, C. It involves exchange of value between parties, or D. It verifies the identities of the parties? The answer is C. It involves exchange of value between parties. Consideration is essential for a contract's enforceability, requiring that value is exchanged between contracting parties. Which element defines that both parties must agree to the same terms in a contract? Is it A. Legal purpose, B. Offer and acceptance, C. Consideration, or D. The answer is B. Offer and acceptance. Offer and acceptance are the foundations for mutual agreement, signifying that all parties understand and agree to the contract terms. In a real estate contract, why is legal purpose crucial as an element? Is it A. It ensures the contract is properly notarized, B. It prevents minority parties from entering the contract, C. It guarantees the contract is for a lawful objective, or D. It requires parties to disclose all property defects? The answer is C. It guarantees the contract is for a lawful objective. The legal purpose requirement ensures that a contract's objective is permissible under the law, thereby making it enforceable. Types of contracts. Which type of real estate contract allows a buyer to occupy the property before closing? Is it A. Lease option, B. Purchase agreement, C. Interim occupancy agreement, or D. Installment sales contract? The answer is C. Interim occupancy agreement. An interim occupancy agreement permits the buyer to move into a property before the sale is officially closed. This is typically used when the closing is delayed for some reason. What is an executory contract in real estate? Is it A. A contract fully performed by both parties, B. A contract that has been canceled, C. A contract not yet fully performed by one or both parties, or D. A contract for deeds only? The answer is C, a contract not yet fully performed by one or both parties. An executory contract is one where some future obligations remain unfulfilled by one or both parties involved. This focuses on pending actions under the agreement. Which contract type typically accompanies a transaction with a delayed final payment? Is it A, option agreement, B, installment sales contract, C, listing agreement, or D, buyer representation agreement? The answer is B, installment sales contract. An installment sales contract allows property purchase over time where the buyer makes regular payments and may not receive the deed until fully paid. What is outlined in a contract for deed transaction in real estate? Is it A, immediate transfer of title at signing, B, payment of contract price directly to the seller in installments, C, use of escrow for handling funds, or D, exchange of titles at contract execution? The answer is B, payment of contract price directly to the seller in installments. In a contract for deed, the buyer makes installment payments directly to the seller. The title is transferred to the buyer only after the full purchase price is paid. Which type of contract gives a buyer the unilateral right to purchase property within a set period? Is it A, lease option, B, purchase agreement, C, option contract, or D, exclusive right to sell? The answer is C, option contract. An option contract provides the potential buyer the unilateral right, but not obligation, to purchase the property within a specified time frame under agreed-upon terms. What is a characteristic of an executory contract in real estate? Is it A, a contract that has been fully performed by all parties, B, a contract where at least some terms remain to be fulfilled, C, a contract that is irrevocable under all conditions, or D, a contract that must be in writing to be enforceable? The answer is B, a contract where at least some terms remain to be fulfilled. An executory contract is one where some terms have not yet been fulfilled. It remains in this state until all parties have completed their obligated actions. What is a primary feature of a unilateral real estate contract? Is it A, both parties are legally bound to perform obligations, B, must be ratified by a third-party entity, C, all terms are negotiable after the contract is signed, or D, only one party is bound until the other party performs an act, M? The answer is D, only one party is bound until the other party performs an act, Mem. In a unilateral contract, one party makes a promise contingent upon the other party's performance of a task, common in option contracts and reward scenarios. Which type of real estate contract can be made orally under some conditions? Is it A, listing agreement, B, purchase and sale agreement, C, lease over 1 year, or D, mortgage agreement? The answer is A, listing agreement. While most real estate contracts are required to be in writing per the statute of frauds, some listing agreements may be oral, though enforceability varies by jurisdiction. Contract clauses and terms. What is an escalation clause in a real estate contract? Is it A, allows buyers to increase their offer in response to competing offers, B, a provision for inspecting the property before closing, C, ensures the buyer's earnest money is returned if financing falls through, or D, identifies the property's assessed value for tax purposes? The answer is A, allows buyers to increase their offer in response to competing offers. An escalation clause allows the buyer to automatically increase their offer price in response to other competitive offers, up to a maximum limit. This clause helps buyers remain competitive in fast-paced markets. In real estate contracts, what does a time is of the essence clause imply? Is it A, parties must perform their obligations within a reasonable time frame, B, Deadlines in the contract are not strictly enforced. C. Failure to meet deadlines can result in breach of contract. Or D. Allows for extension of deadlines without penalty. The answer is C. Failure to meet deadlines can result in breach of contract. A time is of the essence clause stresses the importance of adhering to the timeline outlined in the contract. Failure to do so can result in a breach of contract, underscoring the necessity for punctual performance. What is the purpose of a contingency clause in a real estate contract? Is it A. To ensure that the sale price is negotiable, B. To define penalties for breach of contract, C. To specify conditions under which the contract can be terminated, or D. To list all included appliances and fixtures? The answer is C. To specify conditions under which the contract can be terminated. Contingency clauses in real estate contracts outline conditions that must be fulfilled for the contract to move forward. If these conditions are not met, parties have the option to terminate the contract without penalty. Which clause in a real estate contract obligates the seller to provide a clear title? Is it A. Due diligence clause, B. Warranty clause, C. Appraisal clause, or D. Mortgage clause? The answer is B. Warranty clause. A warranty clause in a real estate contract assures the buyer that the seller is providing a marketable title, free of any claims, to ensure a valid transfer of ownership. What is an option clause in real estate contracts? Is it A. Conditions under which a property's price can be negotiated after an offer is accepted, B. Gives the buyer the right to purchase a property at a set price within a designated time frame, C. Allows sellers to adjust property terms based on market conditions, or D. Lists mandatory repairs before contract closing? The answer is B. Gives the buyer the right to purchase a property at a set price within a designated time frame. An option clause grants the potential buyer the right but not the obligation to purchase property at an agreed price within a specified time period, offering flexibility pending their final purchase decision. What is the primary purpose of an escape clause in a real estate contract? Is it A. To allow a seller to terminate the contract if better offers are received, B. To adjust the sale price according to market changes, C. To provide a fixed time frame for closing the transaction, or D. To permit the buyer to exit the contract under certain conditions? The answer is D. To permit the buyer to exit the contract under certain conditions. An escape clause serves to protect the buyer, offering them the ability to withdraw from the agreement if certain specified conditions are not satisfied. Which of the following clauses defines the time frame within which a real estate contract must be completed? Is it A. Arbitration clause, B. Time is of the essence clause, C. Null and void clause, or D. Contingency clause? The answer is B. Time is of the essence clause. Time is of the essence clause signifies that timely performance by either party is essential in completing contract terms, treating delays as breaches. What does a contingency clause in a real estate contract typically allow? Is it A. Immediate transfer of ownership upon signing, B. Termination of the contract if certain conditions are not met, C. Reduction in purchase price if repair costs arise, or D. Finalization without buyer's financial proof? The answer is B. Termination of the contract if certain conditions are not met. A contingency clause allows contract invalidation if certain conditions, such as financing or inspections, aren't fulfilled, safeguarding parties involved.
If you're finding this helpful, please take a minute to like this video and subscribe to our channel for more practice exams, useful tips, and complimentary study sessions with Birdsey.
Performance, breach, and remedies. What is the most common remedy for breach of a real estate contract? Is it A, monetary damages, B, specific performance, C, liquidated damages, or D, rescission? The answer is B, specific performance. Specific performance is often pursued in real estate contracts because land and buildings are considered unique, making monetary compensation insufficient. This remedy compels the breaching party to fulfill their obligations under the contract. Which of the following describes anticipatory breach in real estate contracts? Is it A, the project is delayed beyond the scheduled completion date? B, a party indicates they will not fulfill their contractual obligations before the due date? C, a mistaken signing of the contract by an unauthorized person? Or D, a breach occurring after partial performance? The answer is B, a party indicates they will not fulfill their contractual obligations before the due date. Anticipatory breach occurs when one party clearly communicates they will not perform the contract in the future. This allows the other party to renege on their obligations and seek remedies for breach. What is a remedy that involves revision of contract terms to reflect the true agreement between parties? Is it A, reformation, B, specific performance, C, novation, or D, rescission? The answer is A, reformation. Reformation is applied when the written contract does not reflect the true agreement due to a mistake or misrepresentation, allowing the courts to amend it to match the party's original intent. Under what circumstances can liquidated damages be claimed in a real estate contract? Is it A, when damages are difficult to estimate and a liquidated figure was previously agreed upon? B, when the buyer does not secure financing? C, if one party is dissatisfied with the property's condition? Or D, whenever a breach occurs automatically? The answer is A, when damages are difficult to estimate and a liquidated figure was previously agreed upon. Liquidated damages clauses are enforceable when actual damages are hard to estimate and the amount is reasonable, preventing penalty imposition. Pre-negotiated sums ease disputes resolution when contract terms are clear. What happens when a breach is regarded as material in a real estate contract? Is it A, the non-breaching party may suspend their own performance? B, the contract automatically terminates? C, liquidated damages are imposed? Or D, the breaching party cannot sue? The answer is A, the non-breaching party may suspend their own performance. A material breach significantly hinders contract fulfillment, allowing the affected party to suspend their responsibilities until the breach is addressed or the contract is terminated legally. Which of the following constitutes performance in a real estate contract? Is it A, completing a home inspection but not notifying parties about results? B, offering a payment extension without written approval? C, making an oral agreement to add conditions to a written contract? Or D, executing all terms and conditions as agreed upon in the contract? The answer is D, executing all terms and conditions as agreed upon in the contract. Contract performance requires the fulfillment of all obligations as stipulated within the contract terms. This ensures both parties complete their legal duties, facilitating the contract's successful execution. What is a potential remedy for breach of a real estate contract by the buyer? Is it A, specific performance, B, liquidated damages, C, statutory rescission, or D, arbitration? The answer is B, liquidated damages. A liquidated damages clause specifies a predetermined sum to be forfeited or paid upon breach, often including earnest money, providing a clear financial consequence for failing to complete the purchase. What legal principle allows a seller to enforce a real estate sales contract despite a buyer's breach? Is it A, specific performance, B, mitigation of damages, C, rescission, or D, accord and satisfaction? The answer is A, specific performance. Specific performance is a legal remedy where a court orders the breaching party to fulfill their contractual obligations, often applicable when the subject matter is unique, like real estate. Which type of breach occurs if a party fails to perform by an agreed date in a real estate contract? Is it A, material breach, B, anticipatory breach, C, actual breach, or D, minor breach? The answer is C, actual breach. An actual breach of contract occurs at the time non-performance occurs when obligations become due. Timely fulfillment of conditions is critical in real estate contracts to maintain legal remedies. Negotiation and acceptance. What is a counteroffer in the context of real estate negotiation? Is it A, a response to an offer that modifies terms, B, an acceptance of the initial offer, C, a rejection of the offer without modifications, or D, the final step in a negotiation process? The answer is A, a response to an offer that modifies terms. A counteroffer alters the initial terms, effectively rejecting the original offer while proposing new terms. It's part of the negotiation process and requires acceptance to form a contract. Which of the following elements is not necessary for a contract acceptance? Is it A, communication of acceptance, B, legal purpose of the contract, C, mutual agreement, or D, personal willingness? The answer is D, personal willingness. While personal willingness might influence an individual's decision to accept, it is not a legal requirement for the formation of a contract. What matters is the agreed terms. In a real estate deal, what does the term acceptance signify? Is it A, the buyer's agreement to the seller's terms with modifications, B, complete agreement to the terms of an offer, C, the starting point of contract negotiations, or D, deciding not to make a counteroffer? The answer is B, complete agreement to the terms of an offer. Acceptance occurs when the offeree agrees to all the terms of the offer as they stand, without changes. This results in the creation of a binding contract. Which scenario constitutes acceptance of a real estate offer? Is it A, seller silently files the signed document, B, seller explicitly states agreement and mails the signed contract, C, buyer calls to discuss changing price terms, or D, seller decides internally to accept the offer? The answer is B, seller explicitly states agreement and mails the signed contract. For acceptance to be legally binding, it must be unequivocal and communicated to the offeror. Simply deciding internally or filing the agreement isn't enough. How does a meeting of the minds relate to real estate contracts? Is it A, it represents an informal understanding between parties, B, to an unspoken agreement on non-essential terms, C, it indicates mutual assent, creating an enforceable contract, or D, it happens when one party agrees under duress? The answer is C, it indicates mutual assent, creating an enforceable contract, A meeting of the minds is the essential moment when all parties have agreed to the terms and conditions of the contract, thus creating a binding agreement. In real estate negotiation, what is the primary purpose of a counteroffer? Is it A, to reject an offer while proposing new terms, B, to accept an offer without modifications, C, to void any previous agreements, or D, to finalize the sale agreement? The answer is A, to reject an offer while proposing new terms. A counteroffer in real estate negotiations serves to reject an initial offer and present alternative terms for agreement. This moves the negotiation process forward to reach mutually acceptable terms.
Thanks for joining us today. If you found this video helpful, subscribe to our channel for more practice exams, tips, and tricks. And don't forget to visit birdsey.ai for complimentary study sessions with Birdsey, your AI-powered study partner.